Rule 130 Rules of Admissibility. Define evidence. Evidence is the means sanctioned by the rules of court as ascertaining in a judicial proceeding the truth respecting a matter of fact. That is Section 1, Rule 128. Evidence also refers to the medium used to prove the existence of or non existence of a fact in issue. Are the rules of evidence the same in all courts and in all trials and hearings? Yes, except as otherwise provided by law or by the rules of court or by Supreme Court issuances. Section 2, Rule 128. So, how is evidence classified according to its nature or form? Evidence is classified according to its nature or form as follows. We can use DOT, documentary evidence, object or real evidence, testimonial evidence. Write, Writings or any material offered as proof of their contents is called documentary evidence. Evidence which is directly addressed to the court's senses is the object or the real evidence. Consists of statement of a witness offered to the court, may be oral, live, or by judicial affidavit, is testimonial evidence. How is evidence classified according to its relation to the fact in issue? Evidence is classified according to its relation to the fact in issue as follows. Direct evidence, that which proves the fact in issue without the aid of any inference or presumption. Circumstantial evidence, that which proves the fact in issue by way of inference or presumption. Distinguish cumulative evidence from corroborative evidence. Cumulative evidence is evidence of the same kind and to the same state of facts, while corroborative evidence is additional evidence of a different character to the same point. This is from Regulatory Remedial Law, Compendium, page 435. More often, however, this fine distinction between cumulative and corroborative evidence is not observed in law and in practice, and corroborative evidence is defined or taken to mean as additional evidence to the same point, whether of the same or different kind. For instance, corroborative evidence in Section 28 of the Rules of on examination of a child witness, which refers to the act or declaration of a child declarant as an exception to the hearsay rule, should be interpreted in the broad rather than in the strict sense. Distinguish prima facie evidence from conclusive evidence. Prima facie evidence is that which by itself is sufficient to prove a fact, but which may be rebutted by contrary evidence, while conclusive evidence is one which may not be rebutted or contradicted. Distinguish positive evidence from negative evidence. Evidence is positive when the witness affirms that a fact did or did not occur, while negative evidence is when the witness states he did not see or know of the occurrence of a fact. When is evidence admissible? Evidence is admissible when it is relevant to the issue and is not excluded by the Constitution, the law, or by the rules of court. Section 3, Rule 128. Or to illustrate it by way of a formula, admissibility equals relevancy plus competency. When is evidence relevant? Evidence is relevant when it has a relation to the fact in issue as to induce belief in its existence or non existence. In civil cases, the fact in issue is one which was raised in the pleadings of the parties. In criminal cases, a fact in issue is one which will establish whether or not the accused is liable or guilty for the offenses charged in the information. Even if a fact tends to prove a matter determinative of the case, but the matter was not put in issue, evidence of such fact is not admissible since it is not relevant. In civil cases, the proponent, however, may avail of Section 5, Rule 10. Distinguish between relevant and material evidence. In certain states in the United States, a distinction is drawn between relevant and material evidence. Evidence is relevant when it tends to prove or disprove a matter determinative of the case, although the matter may not have been put in issue. while evidence is material when it tends to prove or disprove a fact in issue. In Philippine evidentiary law, there is no such distinction because our rule definition of relevant evidence is the same as the American definition of material evidence. What are collateral matters? Collateral matters are those which have no direct connection to the fact in issue. Thus, in a suit on a promissory note by P against D, the fact that D did not pay A in a prior loan is a collateral matter. Is evidence on collateral matters allowed? No, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Section 4, Rule 128. In other words, the existence or non existence of the fact in issue is inferred by induction from the collateral matter. Hence, evidence of the accused's specific nature may be adduced by the defense in a murder charge where the accused had pleaded self defense. Competency. Discuss the concept of competency of evidence. Even if the evidence is relevant, but it is excluded by the law or by the rules of court, the evidence would be inadmissible. Otherwise put, evidence must not only be relevant, but it must also be competent. Competency rules are based on public policy considerations which override the relevancy of the evidence. What are exclusionary rules found, or where are exclusionary rules found? Exclusionary rules are present in the rules of court, for example, those relating to the various disqualification rules and privileges, and in Supreme Court issuances, for instance, the rule on examination of a child witness. They may also be found in the Constitution, such as under Sections 2 and 3, Article 3, right against unreasonable search and seizure, right to privacy of communication and correspondence, Section 12, Article 3, Right of Person under Custodial Investigation, Section 17, Article 3, Right against Self-Incrimination, and in statutes such as the Anti-Wiretapping Law, RA 4200. A sued for annulment of his marriage with B. During trial, A offered in evidence cassette tapes of alleged telephone conversation of B with her lover. The tapes were recordings made by tapping A's telephone line with A's consent and obviously without B's or her lover's. B vehemently objected to their admission on the ground that neither B nor her lover consented to the wiretap. The court admitted the tapes, ruling that the recorded conversations are nonetheless relevant to the issues involved. Was the court correct in admitting the cassette tapes in evidence? The answer is no. The court was not correct in admitting the tapes in evidence. Evidence, in order to be admissible, must be both relevant and competent. Here, the evidence of the telephone conversations, although relevant, were not competent since these are excluded under the anti-wiretapping law. Under the anti-wiretapping law, it shall be unlawful for any person not being authorized by all the parties to any private communication or spoken word to tap any wire or cable, or by using any other device or arrangement to secretly overhear, intercept, or record such communication or spoken word. Any communication or information obtained in violation of the law shall not be admissible in evidence in any judicial, quasi-judicial, legislative, or administrative hearing or investigation. In a disbarment case, introduced in evidence against the respondent was a birth certificate showing that he had fathered children by his mistress. The respondent invokes Article 7 of PD number 603, which provides that the birth records of a person shall be kept strictly confidential and that no information thereto shall be disclosed except on request of the person himself or of a court or proper government official, and which punishes with imprisonment and or fine any unauthorized disclosure. Is a birth certificate admissible in evidence? The answer is yes. Article 7 of PD number 603 only provides for sanctions against persons violating the rule on confidentiality of birth records. But nowhere Does it state that procurement of birth records in violation of said article would render said records inadmissible in evidence? On the other hand, the revised rules on evidence only provides for the exclusion of evidence if it is obtained as a result of illegal searches and seizures. It should be emphasized, however, that said rule against unreasonable searches and seizure is meant only to protect a person from interference by the government or the state. Consequently, in this case where complaints are, as private individuals, obtain the subject birth records as evidence against respondent, the protection against unreasonable searches and seizures does not apply. Since both Article 7 of PD number 603 and the revised rules on evidence do not provide for the exclusion from evidence of the birth certificates in question, said public documents are therefore admissible and should be properly taken into consideration in the resolution of this administrative case against respondent. Tolentino versus Mendoza 440 Scruff 519. Cited in the Jesus versus Sanchez Malit, July 8, 2014. Q. Plunder cases were filed against former President Estrada before the Sandigan Bayan. The prosecution moved for the issuance of a subpoena duces tecum directed to Equitable Bank and Urban Bank to produce the records relative to trust account number 858 and savings account number 0016173459. Estrada moved to quash the subpoena desus tecum. Estrada contends that the information found therein, given their extremely detailed character, could only have been obtained by the prosecution through an illegal disclosure by the bank officials concerned. Estrada thus claims that the subpoenas must be quashed following the fruit of the poisonous tree doctrine. Is Estrada's argument correct? The answer is no. The exclusionary rule is inapplicable. RA number 1405 nowhere provides that an unlawful examination of bank accounts shall render the evidence obtained therefrom inadmissible in evidence. Section 5 thereof only provides for criminal liability to the violator. Hence, the subpoenas cannot be quashed. Ejercito versus Sandigan Bayan, November 30, 2006. Define documentary evidence. Documentary evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Section 2 of Rule 130, as amended by 2020 amendments to the revised rules on evidence. What is the meaning of recording under Section 2, Rule 130? A recording consists of letters, words, numbers, or their equivalent recorded in any manner. Under Section 2, Rule 130, as amended by the 2020 amendments, recording includes sounds. Hence, a recording of a conversation, speech, or other oral communication is considered as documentary evidence. Johns versus United States, 232 F2D 421. Fifth Circular 1963, cited in the notes of the Advisory Committee to the FRE 2019. What is the meaning of photographs under Section 2130? A photograph means a photographic image or its equivalent stored in any form, offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray, films, motion pictures, or videos. Section 2, Rule 130, as amended by the 2020 amendments. Hence, a CCTV footage of a person robbing a bank is considered as a photograph included in the definition of documentary evidence. A witness was presented on the stand to testify that he saw the accused robbing the bank and that he also saw a CCTV footage of the accused robbing the bank. The defense counsel objected to the portion of the testimony regarding the CCTV footage, saying that the best evidence or the original document is the footage. Should the objection be sustained? No. If a witness is presented on the stand to identify the photograph or motion picture as a correct representation of events which he saw or of a scene which he is familiar, he adopts the picture as his testimony, or in common parlance, uses the picture to illustrate his testimony. Under these circumstances, no effort is made to prove the contents of the picture, and the original document rule is inapplicable. Paradis, the celluloid witness, 37, U. Colo L. Revise or Review 235, 249 to 251. May a document be offered as object evidence? Yes, if the document is offered not as proof of its contents, but of its existence or physical condition or features, then it is considered as
July
object
2018.
evidence.
That
Hence,
ends examples
marked money
for
used in a buy
Rule
bust
8.
operation and offered to prove the buy bust is object evidence. A paper containing the handwriting of a person offered as a handwriting exemplar is an object evidence. Milagros, the plaintiff's wife, forged plaintiff's signature in a special power of attorney, purportedly authorizing Milagros to sell their conjugal land. Armed with a forged SPA, Milagros sold the land to the defendant, Pan. The price indicated in the deed of sale was $200,000. According to the defendant, what he really paid was $700,000. But Milagros had requested the price to be understated in order to save on taxes. The trial court nullified the sale and ordered Milagros and plaintiff to return the purchase price of $200,000 to the defendant. On appeal, the defendant argues that the trial court erred in relying on the consideration stated in the deed of sale as basis for the reimbursable amount because a null and void document cannot be used as evidence. Is the defendant correct? No. While the terms and provisions of a void contract cannot be enforced, since it is deemed inexistent, it does not preclude the admissibility of the contract as evidence to prove matters that occurred in the course of executing the contract. That is, what each party has given in the execution of the contract. The deed of sale as documentary evidence may be used as a means to ascertain the truthfulness of the consideration stated in its actual payment. The purpose of introducing the deed of sale as evidence is not to enforce the terms written in the contract, but to determine what each party has given under the void contract to allow restitution and prevent unjust enrichment. Tan versus Hosanna, February 3, 2016. When a rule of evidence refers to the term writing, document, record, instrument, memorandum, or any other form of writing, does such term include an electronic document? Yes. An electronic document is a functional equivalent of a paper-based document. Section 1, Rule 3, Rules on Electronic Evidence. What is the original document rule? The original document rule provides that when the subject of inquiry is the contents of a document, writing, recordings, photographs, or any record, no evidence is admissible other than the original document itself. Section 3, Rule 130, as amended by the 2020 amendments. The rule was formerly known as the best evidence rule prior to the 2020 amendments. The 2020 amendments have adopted the more precise term original document rule. The prosecution witness testified that he saw a CCTV footage of the accused robbing the bank. The defense counsel objected on the ground of the original document rule. The prosecutor argued that the CCTV footage is not a document since it is not a writing. Should the defense counsel's objection be sustained? Yes. Photographs, which includes motion pictures or videos, are expressly included in the definition of documentary evidence under Section 2, Rule 130, and in the original document rule under Section 3, Rule 130 of the 2020 Rules on Evidence. Is there a difference, or is there a different original document rule for electronic documents? In the main, no longer. Formerly, there was a bifurcated or bifurcated approach to the original document rule, one for non-electronic documents under the rules of court and another for electronic documents under Rule 4 of the Rules on Electronic Evidence. The key distinction was that under the rules on electronic evidence, duplicates were considered as the equivalent of the originals. Section 2, Rule 4 of the Rules on Electronic Evidence. The 2020 amendments in the main provide for a uniform approach to the original document rule when it also adopted the rule in Section 2, Rule 4 of the Rules on Electronic Evidence by providing that a duplicate is admissible to the same extent as the original. Mr. Carrascosa took an Air France flight from Manila to Rome. While on a stopover in Bangkok, he was forcibly transferred from the first class to the tourist class in order to make way for a white man. Mr. Carrascosa resisted this transfer and a commotion occurred on board the plane. The purser recorded the incident in his notebook. Mr. Carrascosa sued Air France. During the trial, Mr. Carrascosa testified that after his forcible transfer to the tourist class, the purser told him that he, the purser, had recorded the incident in his notebook and then read out the entry to him. First class passenger was forced to go to the tourist class against his will, and the captain refused to intervene. Air France counsel moved to strike out the statement on the ground that the original evidence would be the notebook. Should the court grant the motion to strike out? No. The court should not grant the motion to strike out. The original document rule applies when the subject
If a
of
compulsory
inquiry is the
counterclaim or
contents of the
cross-claim
document.
not set up is
Here,
made
the
the subject
of inquiry
of a
is not the
separate action,
contents of
what
the
is the
notebook, but
remedy
the
of the
purser's
defendant?
statement to
The
Mr.
remedy of the
Carrascosa.
defendant is to file a
Otherwise
motion
put,
to dismiss
the
or
original
answer raising the
document
ground
rule
of leading
applies only to
pendentia if the
documentary
first
evidence,
case is still
but not to
pending,
testimonial
or the ground of
or
res
oral
judicata if the
evidence.
first case
The
is already
purser's
final and
statement was not
unappealable.
written,
The
but
basis for
oral
this
in
is
form.
that
Air
under
France
Section
versus
47 letter B of
Carrascosa.
Rule 39, the final
Each
judgment is
insured
conclusive
or
not
insured
only with
his
respect
wife
to the matter
with X
directly adjudged,
insurance
but also as to
company
any other matter
and
that could
designated
have been
W as
raised
the
in relation
beneficiary.
thereto.
The
Metals
policy
Engineering
provided that the
Resources
beneficiary
Corporation
could be
versus Court of
changed by a
Appeals.
written notice
GR
designating the new
95631.
beneficiary
He
sent by
sues
the
the
insured
court.
and
He
received by
files a
the
motion to dismiss on the
ex-insurance
ground that
company
res judicata.
before the
The
death
court
of the
dismisses his
insured.
complaint, and the
After the
dismissal
death
order
of
becomes final
H,
and
Q
unappealable.
demanded from
Later, these
ex-insurance
two speak
company
for moral and
the
exemplary
proceeds of
damages
the
for having
policy,
brought a
claiming
harassment
that she had
suit.
been
He moves to
designated
dismiss on the
as the
ground that the
beneficiary
claim for
by
moral and
H,
exemplary
as may be
damages
seen from
should
a
have been
copy of
brought
a
as a
written notice
counterclaim in
signed
the
by
torts
H
case.
and
Should a motion
allegedly
to dismiss
received
be
by
granted?
ex-insurance
Yes.
company
Had
before
D
his
wanted
death.
to prosecute his claim for moral and
Q
exemplary
sues
damages,
ex-insurance company for
he
its
should have not
refusal to
filed a motion
deliver
to
the
dismiss with an
proceeds
answer
of the
wherein he
policy
should
to
have
her.
raised res judicata as an
Ex-insurance
affirmative defense
company
and
raises the
included a
defense that
counterclaim
it
in the
did
answer
not,
for moral and
before
exemplary
H
damages.
death,
Not having done so,
receive
the
from
claim for
H the
damages is
required
barred
written
under Section
notice changing the
209.
beneficiary from W to Q.
Declaration
At
of
the
default.
trial, Q did
When
not
may a
produce the
defendant be
copy of the
declared in
written
default?
notice
What happens
supposedly
thereafter? If
received
the
by
defendant fails to
ex-insurance
answer within
company.
the time allowed
Instead,
therefor,
Q
the
merely
court shall, upon
presented
motion of
R,
the
who
claiming party,
testified that
with
shortly
notice
before
of the
H
defending
death,
party and proof
H
of
had
such failure,
instructed
declare
R
the
to write to
defending party in
ex-insurance
default.
company
Thereupon,
to that
the court
effect.
shall, number one, proceed to render
R's
judgment
testimony
granting the
was
claimant
objected
such
to
relief
on the
as his
ground that
pleading
it
may
was in
warrant, or,
violation of the
in its
original
discretion,
document rule.
require the claimant to
The
submit
original
evidence.
document rule
Rule
being the written
9,
notice,
Section
rule
3.
on the objection.
May the reception of evidence be
The objection
delegated?
of
Yes, it may
that
be delegated to the
R's
clerk of
testimony
court,
was in
who
violation
must be a
of
member
the
of the
original
bar.
document rule
Section
should be
3, Rule
overruled.
9.
The original
Should a
document
motion
rule
to declare
applies
defendant
only
in
to
default
documentary
be set for
evidence.
hearing? While such
Testimony
a
by
motion
R
is
on what H
litigious
had
motion,
told him
a hearing
to
is
do
discretionary
not
upon the court.
testimony
Section 6, Rule
on
15.
documentary
The defendant,
evidence.
however, should be given the
Air
chance
France
to oppose
versus
the motion to
Carrascosa.
declare him in default.
At the
May the court
trial
motu
of Ace
proprio
for
declare
violation of the
defendant
Dangerous
in
Drugs
default for
Act,
failure to timely
the
file an answer?
prosecution
No.
offers in
There should be a
evidence
motion by the
photocopy of the
plaintiff.
marked
Note, however,
100
that under the
bills
rules and summary
used in
procedure, the
bypass
court may
operation.
motu proprio
Ace
render
objects to the
judgment in favor of
introduction
the
of the
plaintiff if the
photocopy of the
defendant
ground
fails
that
to
the best
timely
evidence rule
answer.
prohibits the introduction of secondary evidence in lieu of the original. Is the photocopy real, object evidence, or documentary evidence? Number 2. Is the photocopy admissible in evidence? Answer to number 1. The photocopy is real or object evidence because the same is being offered not to prove the contents of the marked money, but to prove its existence and use in the buy bust operation. The photocopy is admissible in evidence. The objection that the introduction thereof would violate the best evidence rule does not lie, since the best evidence rule does not apply to object or real evidence. People versus Tandoy. Police officers arrested Mr. Draghi in a buy-bust operation and confiscated from him 10 sachets of shabu and several marked genuine peso bills worth 5,000, used as the buy-bust of money during the buy-bust operation. At the trial, Mr. Draghi, for violation of RA number 9165, Comprehensive Dangerous Drugs Act of 2002, the prosecution offered in evidence, among others, photocopies of the confiscated marked genuine peso bills. The photocopies were offered to prove that Mr. Draghi had engaged at the time of his arrest in the illegal selling of dangerous drugs. Invoking the best evidence rule, Attorney Maya Bang, the defense counsel, objected to the admissibility of the photocopies of the confiscated marked genuine peso bills. Should the trial judge sustain the objection of the defense counsel? No, the trial judge should not sustain the objection of the defense counsel. In a case involving similar facts, the Supreme Court held that the offering evidence of the photocopied marked money did not violate the best evidence rule, since such a rule applies only to documentary and not to object evidence. Here, the marked money was offered not to prove the contents thereof, but to prove the fact that Mr. Draghi had sold the illegal drugs to the poster buyer. People versus Tandoy. Prosecution of D for kidnapping. Prosecution witness W testifies that he received a ransom note. D objects on the ground that the original evidence is the note itself. Should the objection be sustained? No. The original document rule does not apply if what is being testified to is not the contents of a document but the fact of receipt of a document. But if W will testify on the terms or contents of the note, D can object on the ground of the original document rule. Under the original document rule, what is regarded as the original? An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. If data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. Section 4, letter B, Rule 130 as amended. What is a duplicate? A duplicate is a counterpart produced by the same impression as the original, or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronic recording, or by chemical production, or by other equivalent techniques which accurately reproduce the original. Section 4, letter B, Rule 130 as amended by the 2020 amendments. A duplicate means a counterpart produced by a mechanical, photographic, chemical, electronic, or other equivalent process or technique that accurately produces the original. Proponent presents in evidence a photocopy of a letter written by the adverse party without accounting for the non-production of the original letter. The adverse party objects on the ground of the original document rule. Should the objection be sustained? The answer is no. The objection should be overruled. A photocopy is a duplicate since it is a counterpart produced by photography, which is a technique which accurately reproduces the original. Under Section 4, letter C of Rule 130, a duplicate is admissible to the same extent as an original unless 1. A genuine question is raised as to the authenticity of the original, or 2. In the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. Under the former best evidence rule, the objection would have been sustained since the photocopy is considered as secondary evidence. What are the exceptions to the original document rule? The exceptions to the original document rule is in which evidence other than the original document is admissible to prove the contents of the documents are Club C. C would be original is in the custody or control of the adverse party and he fails to produce it after reasonable notice. O, the original cannot be obtained by a local judicial process or procedures. L, the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. Letter A, original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established is only the general result of the whole. P, original is a public record in the custody of a public officer or is recorded in a public office. C, the original is not closely related to a controlling issue. Court's discretion to dispense with production of original. At issue was whether or not President Joseph Estrada resigned from the presidency. Presented in support of the contention that Estrada resigned were the excerpts from the Angara diary in which Estrada stated, "Pagod na ako. Ayoko na, masyado na masakit. Pagod na ako sa red tape, bureaucracy, sa intriga. I just want to clear my name, then I will go." Estrada objected to the introduction of the excerpts on the ground that the best evidence is the Angara diary itself. Is the objection meritorious? No. The Supreme Court adopted Wigmore's comment that production of the original may be dispensed with in the trial court's discretion if the opponent does not bona fide dispute the contents of the document and no other useful purpose will be served by requiring production. Here, Estrada did not bona fide dispute the contents of the excerpts, even though he was in a position to do so. Estrada versus Distiero. Petitioner Concepcion Chua and respondent Sui Ben Chua are the children of the late Chua Chin. Upon the demise of Chua Chin, his spouse and his children executed a deed of partition wherein they waived their shares over the Hagone lumber in favor of their co-heir Chua Shokhan. Chua Shokhan then sold the Hagone lumber to respondent. Later, respondent delivered a check for 200,000 to petitioner, which the latter encashed. Subsequently, respondent sued petitioner to collect on the 200,000, which the respondent alleged was a loan. In her answer with counterclaim, petitioner alleged that the 200,000 was an advance on her share in Hagone lumber and counterclaimed for accounting and delivery of her share. Respondent filed an answer to the counterclaim wherein he alleged that petitioner no longer had any interest in Hagone lumber because of the execution of the deed of petition, and then he is now the owner of the Hagone lumber by virtue of a deed of sale executed in his favor by Chua Shokhan. Respondent annexed copies of the deed of petition and of sale to his answer to the counterclaim. Petitioner filed an unsworn reply and countered that the deed of petition and the deed of sale were not true and valid agreements and did not express the true intention of the parties, and that the deeds were only temporary paper arrangements executed upon the advice of counsel until all the heirs could reach a final agreement. The trial court ruled in favor of respondent. Petitioner contended that it was error for the trial court to admit mere copies of the deed of partition and the deed of sale in violation of the best evidence rule. Is the petitioner's contention correct? No, the petitioner's contention is not correct. The Supreme Court has held in Gao versus Chua, GR 16855, that production of the original may be dispensed with in the trial court's discretion, whether or whenever the opponent does not bona fide dispute the contents of the documents and no other useful purpose will be served by requiring production. Here there was no dispute as to the terms of either deed. Hence, the RTC correctly admitted the photocopies in evidence. Petitioner admitted signing the deed of partition. As for the deed of sale, petitioner, in effect, admitted the genuineness of the due execution of deed of sale when she failed to specifically deny it pursuant to Section 8, Rule 8. The petitioner did not contest the contents of the deeds, but simply alleged that there was a contemporaneous agreement that the transfer of Hagone lumber to Chua Shokhan was only temporary. Note, although the petitioner was not a party to the deed of sale between Chua Shokwan and respondent and therefore is not required to deny it under oath, she must still specifically deny its genuineness and do execution. This petitioner failed to do so, so she impliedly admitted the same pursuant to Section 8, Rule 8. What is secondary evidence under the original document rule? Secondary evidence is that other than the original document or an equivalent thereof, which may be used to prove the contents of a document, where the case falls within any of the exceptions to the original document rule. What is the secondary evidence when the original document is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer? Upon proof of the execution or existence of the original and the cause of its unavailability, the offerer may prove its contents by a copy or by a recital of its contents in some authentic document or by the testimony of witnesses in others stated or in the order stated. Is there an order of priority in the use of secondary evidence under Section 5, Rule 130? Yes. Section 5, Rule 130 states that the offerer may prove the original document by copy or recital or by testimony of witnesses in order or in the order stated. So, original document by a copy, a recital, or by testimony of witnesses. This means that before the offerer may resort to a recital, he must first show that the copy is unavailable. And before he may resort to testimonial evidence, he must first show that a copy and a recital are unavailable. What is the proper foundation for the introduction of secondary evidence in the case of loss, destruction, or inability to produce the original? The offerer must show EUR, proof of the execution or existence of the document. Number two, proof of the cause of its unavailability without bad faith on his part. Number three, proof of reasonable diligence and good faith on the part of the offerer in the search for or attempt to produce the original. Citibank versus Chodoro, GR 150905, September 23, 2003. What is the proper foundation for the introduction of secondary evidence in the case of loss, destruction, or inability to produce the original? The offerer must show EUR, proof of the execution or existence of the document, of the cause of its unavailability without bad faith on his part, proof of reasonable diligence and good faith on the part of the offerer in the search for or attempt to produce the original. Citibank versus Chodoro. The original document was lost because of the offerer's negligence. May he use as secondary evidence to prove the contents of the original? Yes. Section 5, Rule 130 states that secondary evidence may be introduced by the offerer upon proof of its execution or existence and the cause of its unavailability without bad faith on his part. This means that it is bad faith, not negligence, which would preclude the offerer from using secondary evidence. Ajax Power Corporation, a utility company, sued in the regional trial court to enforce a supposed right-of-way over a property owned by Simplicio. At the ensuing trial, Ajax presented its retired field auditor who testified that he knew for a fact that a certain sum of money was periodically paid pursuant to a written contract. The original contract was not presented. Instead, a purported copy identified by the retired field auditor as such was formally offered as part of his testimony. Rejected by the trial court, it was finally made the subject of an offer of proof by Ajax. Can Ajax validly claim that it had sufficiently met its burden of proving the existence of the contract establishing its right of way? No. Ajax cannot validly claim that it had sufficiently met its burden of proving the existence of the contract, establishing its right of way. Under the best evidence rule, before a party may introduce secondary evidence of an original document, he must first lay the foundation by proving the execution or existence of the original document. Here, Ajax Field's auditor testified only as to the payment of a certain sum of money pursuant to a contract, but did not positively state that there was an original contract of right of way in the first place. Here, the copy was inadmissible in evidence. Manila Electric Company versus IAC GR 71393. Defendant was a card holder of Citibank Mastercard. When defendant uses the credit card in purchasing from a merchant, triplicates were produced by the sales invoice or of the sales invoice. Although the cardholder signed the sales invoice only once, one copy was for Citibank, another to the merchant, and another to the defendant cardholder. Citibank subsequently sued defendant for unpaid credit cards debts. During the trial, Citibank offered in evidence photocopies of the sales invoices or charge slips to prove the obligation of the defendant. Citibank's assistant manager testified that he had requested the original from Equitable Credit Card Network, but this request was not accepted upon by Equitable. Defendant objected to the introduction of photocopies of being violative of the best evidence rule. How should the court rule on the objection? The court should sustain the objection. The Supreme Court has held that there should be reasonable diligence and good faith in the search for or attempt to produce the original. Here, the original sales invoices might have been found by Equitable. Hernandez testifying that he had requested the originals from Equitable failed to show that he had subsequently followed up the request. Moreover, when more than one original exists, it must appear that all of them have been lost, destroyed, or cannot be produced in court before secondary evidence can be given to anyone. A photocopy may not be used without accounting for her other originals. Not her, but for other originals. Each of the triplicate is considered an original in accordance with Section 4, Rule 130. Citibank failed to show that all three originals were unavailable and that due diligence had been exercised in the search for them. Citibank versus Teodoro. H insured his life with X insurance company and designated W as the beneficiary. The policy provided that the beneficiary could be changed by a written notice designating the new beneficiary sent by the insured and received by the X insurance company before the death of the insured. After the death of A or H, Q demanded from X insurance company the proceeds of the policy, claiming that she had been designated as the beneficiary of H, as may be seen from a copy of a written notice signed by H and allegedly received by X insurance company before H death. X sues or Q sues X insurance company for its refusal to deliver the proceeds of the policy to her. X insurance company raises the defense that it did not, before H death, receive from H the required written notice changing the beneficiary from W to Q. At the trial, Q did not produce a copy of the written notice supposedly received by X insurance company. Instead, Q merely presented R, who testified that shortly before H death, H has instructed R to write to X insurance company to that effect, and that shortly thereafter, and before his death, he or received in the mail a card from X insurance company on which was written acknowledged receipt of notice of change of beneficiary from W to Q, but that the card had been mistakenly thrown away. R's testimony was objected to on the ground that it is in violation of the best evidence rule, the best evidence being the card bearing the acknowledgement of receipt. Rule on the objection. Objection sustained. In order for secondary evidence in the form of testimonial evidence to be admitted, the proponent should have laid the basis therefore pursuant to Section 5, Rule 130. Here, while our testimony that the card was mistakenly thrown away may have been adequate to existence of the card and its subsequent loss or unavailability, his testimony did not show that a copy of the card or an authentic recital thereof was also unavailable. Hence, the objection should be sustained. What is the proper foundation for the introduction of secondary evidence in the case where the original is in the custody or control of the party against whom the evidence is sought to be offered? The same. The offerer must show ER, the proof of the existence of the document, proof of reasonable notice to produce to the adverse party and failure to produce. P filed against D an action for the recovery of a stock certificate wrongfully obtained and withheld by D. P offered in evidence a photocopy of the stock certificate. D objected on the ground of the best evidence rule and stated that no notice to produce the original was given to him. P counters that a notice to produce is not necessary where the nature of the action is in itself a notice and where the document has been wrongfully obtained or withheld by the adverse party. How should the court rule on these objections? Explain. The court should sustain this objection. The provision in the former, Section 6130, which states that the notice to produce is not necessary where the writing is itself a notice or where it has been wrongfully obtained or withheld by the adverse party, has been deleted in the present Section 6 Rule 130. What is the secondary evidence in the case of the exception under Section 3, letter C, regarding numerous accounts? The contents of the numerous accounts or documents may be presented in the form of a chart, summary, or calculation. The originals shall be available for examination or copying or both by the adverse party at a reasonable time and place. The court may order that they be produced in court. Section 7, Rule 130 of the 2020 Rules on Evidence. What is the condition precedent for the admission of a summary of numerous documents under Section 3, letter C 130? The trial court may admit a summary of voluminous original documents in lieu of original documents if the party has shown that the underlying writings are numerous and that an in-court examination of these documents would be inconvenient. In other words, Section 3, letter C of 130 does away with the item-by-item court identification and authentication of voluminous exhibits, which would only be burdensome and tedious for the parties and the court. However, a condition or as a condition precedent to the admission of a summary of numerous documents, the proponent must lay a proper foundation for the admission of the original documents on which the summary is based. The proponent must prove that the source documents being summarized are also admissible if presented in court. In concrete terms, the source documents must be shown to be original and not secondary. Furthermore, the source documents must likewise be accessible to the opposing party so that the correctness of the summary of the voluminous records may be tested on cross-examination and or may be refuted in pleadings. In ordinary trial type proceedings, a proper foundation for the introduction of a summary may be established through the testimony of the person who is responsible for the summary's preparation or the person who supervised the preparation of the summary. Furthermore, when a party invokes Section 3, letter C of 130, he does not similarly invoke Section 3, letter A, B, and or D of 130. He does not likewise claim that the original documents have been lost or destroyed. The party merely asserts that the numerous documents cannot be examined in court without great loss of time and that the fact sought to be established from these documents is only the general result of the whole. Whenever a party seeks an exemption under the best evidence rule pursuant to Section 3, letter C of 130, he asks permission from the trial court to produce a summary of numerous documents whose originals are available to the adverse party for inspection. He does not ask permission from the trial court to present in evidence the numerous non original documents. Otherwise, the very purpose of Section 3, letter C 130 would be defeated. In that case, every exhibit of non original documents would be identified, authenticated, and cross examined, leading to a tedious and protracted litigation. Thus, if a party desires to present photocopies of the original document, he must first establish that the presentation of photocopies is justified under Section 3, letter A, B, and or D of 130. He must establish the presence of all the elements under these provisions. Republic versus MUPAS, September 8, 2015. Thus, in a case, the Supreme Court said that it could not give any weight to a summary of costs prepared by an auditing firm since the firm did not state in its summary that it examined the original documents, allegedly proving the costs. Although a compliance was later submitted, the same merely consisted of photocopies whose presentation was not shown to be justified under Section 3, letter A, B, and or D of 130. What is the secondary evidence in case where the original is a public record? The contents of the public record may be proved by a certified copy issued by the public officer in custody thereof. Public record or recorded in a public office. Respondent offered in evidence Exhibit H, a photocopy of a deed of sale. On the photocopy is a stamped notation signed by an assessment officer in the local assessor's office which states that the photocopy is a certified true Xerox copy. The petitioner objected to the offer on the ground that it violates the best evidence rule, but the trial court overruled the objection and admitted the photocopy. Was the admission of the photocopy in evidence proper? No, on two grounds. First, the attestation made by the assessment officer is defective, for it did not state that the copy is a correct copy of the original. See Section 25, Rule 132. Second, the assessor's office is not the official repository of original notarized deeds of sale and could not have been the legal custodian contemplated in the rules. It is the notary public or the proper court that has custody of his notarial register that could have produced the original or a certified true copy thereof. Ears of Gabatan versus Court of Appeals, GR 150206. PCGG, on behalf of the Republic, filed a complaint for reversion against former President Marcos. Upon his death, he was substituted by his heirs. During the trial, the PCGG presented certified true photocopies of Pantranco's Articles of Incorporation, Memorandum of Agreement, and Purchase Agreement. The PCGG also presented a photocopy of the proceedings before the PCGG. These were objected to by respondents on the ground that they violate the best evidence rule. Petitioner contends that these documents fall within the exception under Section 3, letter D of 130, that is, these documents are public records in the custody of a public officer or are recorded in a public office. It is in its theory that since these documents were collected by the PCGG, then necessarily the conditions for the exceptions to apply had been met. Should the objections be sustained? The answer is yes. The fact that Pantranco's Articles of Incorporation, Memorandum of Agreement, and a Purchase Agreement were collected by the PCGG in the course of its investigation of the Marcoses' alleged ill-gotten wealth do not make the same public records within the purview of Section 3, letter D, and Section 7 of Rule 130, as well as Section 19, letter C of Rule 132. As to the copy of the TSN of the proceedings before the PCGG, while it may be considered as a public document under Section 19, letter A of Rule 132, since it was taken in the course of the PCGG's exercise of its mandate, it was not attested to by the legal custodian to be a correct copy of the original. This submission falls short of the requirement of Section 24 and Section 25 of Rule 132. Republic versus Marcos Manotoc, GR 17-1701. Plaintiff filed case against defendant. A document needed by plaintiff to prove his case is in the possession of X, but despite the issuance of a subpoena disus tecum, the document could not be obtained because the subpoena could not be served on X whose whereabouts are unknown. May the plaintiff introduce secondary evidence in lieu of the original document? The answer is yes. The 2020 rules introduce another exception to the original document rule. That is, when the original cannot be obtained by local judicial processes or procedures. Explain the exercise or exception where the original is not closely related to a controlling issue. This essentially refers to the situation wherein the contents of the document are not the subject of the inquiry. Thus, in a case wherein the parties do not dispute the terms of a contract, the issue being whether there was a breach of the contract, secondary evidence of such contract is admissible. Best evidence rule under the rules on electronic evidence. The rules on electronic evidence are those rules applicable whenever an electronic document is offered or used in evidence. When did the REE take effect? It took effect on August of 2001. Whether the cases covered by the REE. The REE shall apply to all criminal and civil actions and proceedings, as well as quasi judicial and administrative cases. Section 2 of Rule 1 of the revised or the Rules on Electronic Evidence REE. Police officers invited suspect Enojas to come with them aboard their car. Later, the police get involved in a firefight at a 7-Eleven store in which one gunman and one officer was killed. In the confusion, Enojas disappeared but left his cell phone in his cab. Officer Cambi got the cell phone and pretending to be Enojas was able to cause the entrapment and arrest of the suspects in the killing. Enojas was himself arrested. The accused were charged with murder. The text messages sent to the phone recovered from the taxi driven by Enojas clearly made reference to the 7-Eleven shootout and to the wounding of Kuya Justin, one of the gunmen, and his subsequent death. The context of the messages showed that the accused were members of an organized group of taxicab drivers engaged in illegal activities. May the transcript of the text messages be used in evidence against the accused? Yes. As to the admissibility of the text messages, the regional trial court admitted them in conformity with the court's earlier resolution applying the rules on electronic evidence to criminal action. AM number 01701 Supreme Court. Re-expansion of the coverage of the rules on electronic evidence September 24, 2002. Text messages are to be proved by the testimony of a person who was a party to the same or has personal knowledge of them. Here, PO3 can be posing as the accused Enojas exchanged text messages with the other accused in order to identify and entrap them. As the recipient of those messages sent from and to the mobile phone in his possession, PO3 Cambi had personal knowledge of such message and was competent to testify on them. People versus Enojas, March 10, 2014. Note, the pronouncement as to the inclusion of criminal actions and proceedings in the coverage of the REE cleared up doubts engendered by Ang versus People, GR 1828-35, April 20, 2010, where the Supreme Court in an obiter stated that the free or the re does not apply to criminal actions. What is an electronic document? An electronic document is defined in the re as information or the representation of information, data, figures, symbols, or other modes of written expression by which a right is established or an obligation extinguished or by which fact may be proved, which is received, recorded, transmitted, stored, processed, retrieved, or produced electronically. Section 1, letter H, Rule 2, re. It includes digitally signed documents and printout. What is an electronic data message? An electronic data message refers to information generated, sent, received, or stored by electronic, optical, or similar means. Section 1, letter G, Rule 2, REE. For purposes of the REE, the term electronic document may be used interchangeably with electronic data message. So give example of electronic documents. Example of electronic documents are emails, recorded of saved text messages, and computer generated documents. A document which is scanned is also an electronic document. State the rule on admissibility of electronic documents. An electronic document is admissible in evidence if it complies with the rules on admissibility prescribed by the rules of court and related laws and is authenticated in the manner prescribed by the rules on electronic evidence. What is the original of an electronic document? An electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is a printout or output readable by sight or other means shown to reflect the data accurately. The image of an electronic document shown in the monitor is an original, as well as the printout thereof. Is a copy or duplicate considered an equivalent of the original under the REE? Yes, under the REE, copies or duplicates are considered as the equivalent of the original. Section 2, Rule 4. Thus, a photocopy of an email printout is admissible without accounting for the non-production of the original. Under the 2020 amendments, the best evidence rule under the REE is substantially similar to the original document rule under the rules on evidence. What is a copy or a duplicate? The following are considered copies or duplicates. Duplicate originals when a document is in two or more copies executed at or about the same time with identical contents, or counterpart when a document is a counterpart produced by the same impression as the original or from the same matrix, or by mechanical or electronical re-recording, or by chemical production, or by other equivalent techniques which accurately produces the original. A photocopy is a counterpart and hence equivalent to the original. So when is a copy or duplicate not admissible to the same extent as the original? A copy or a duplicate shall not be admissible to the same extent as the original if a genuine question is raised as to the authenticity of the original, or in the circumstances it would be unjust or inequitable to admit the copy in lieu of the original. So, is the best evidence rule under the rules on electronic evidence applicable to non electronic documents? A perusal of Section 2, Rule 4 of REE would indicate that it applies to electronic and non electronic documents, as the term electronic document is not used therein. Indeed, FRE 101, number 4, and 103, from which Section 4, Rule 4 REE was substantially copied, applies to all kinds of documents without distinction. Professor Jesus Decini Jr. writes that Section 2, R4, is a substantial amendment to the best evidence rule that affects even paper-based documents. Are text messages ephemeral electronic communications? Yes. Once saved or recorded, however, they become electronic documents and are thus subject to the best evidence rule. Do evidentiary rules and documents such as the best evidence rule and the parole evidence rule apply to electronic documents? Yes. Whenever a rule of evidence refers to the term writing, document, record, instrument, memorandum, or any other form of writing, such terms shall be deemed to include an electronic document. Parole evidence rule. Let's pick up from here on the next upload. And again, thank you so much for your support. If you're not a subscribe to our channel, please hit that subscribe button and let's study together. Again, please forgive the mispronounced words. We are rushing.